Have you been charged with a felony? What are your options? What can you do to fight back? Hi, I'm Jeff Hampton with the Hampton Law Firm. Thanks for joining us on our YouTube channel today. Today I want to talk to you about felony charges in Texas. What can you do about it? What are some of your defenses? If you are convicted of a felony, what are the long-term ramifications? What are the consequences? And if you wait around to the end of this video, I'm also going to give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Okay, so let's jump into this. Listen, Texas law breaks down basically criminal actions into two particular designations. Felony crimes, which are the most serious, misdemeanor crimes, which are obviously less serious with less penalties. The state of Texas punishes felony crimes with anywhere from up to a 10-year probation all the way up to life in prison. So really depending upon the nature of the charge and what level of charge that it is. There can also be very high fines and fees. And the court system really breaks down the type of felony into degrees. There are degrees of felony. Let's give you an example. Capital felony, everyone knows about this. A capital felony is like capital murder. You could be punished by up to life in prison or the death penalty under that option. A first-degree felony is punishable by up to life in prison and up to a $10,000 fine. A second-degree felony is punishable by a minimum of 2 years up to 20 years in prison and up to a $10,000 fine. Then you get to a third-degree felony. A third-degree felony is punishable by a minimum of 2 up to 10 years in prison and up to a $10,000 fine. And then there is a state jail felony. State jail felony is the lowest level of felony. It has a minimum of a 180-day sentence up to a 2-year sentence. But it is not in the Texas Department of Corrections prison system. It is actually a separate system called a state jail facility. It's still prison, but it's in a different unit, okay? So those are some examples. Now, the number one question I get from people all the time, if I've been charged with a felony, is jail or prison time a requirement? Will I have to go to prison or jail if I'm charged with a felony? Well, not necessarily, because even under the worst set of circumstances, if it's your first felony offense, you may be able to escape a prison sentence or a jail sentence if your criminal attorney is able to go in, negotiate a resolution with the prosecutor that keeps you out of prison. Because here's the thing, when people call me, the number one goal, if you're facing a felony case, it starts with trying to stay out of prison. That's number one. Number two, we want you to not be a convicted felon, okay? Number three, we want you to be able to get this off your record. Now, we take them in that order because none of the rest of that matters if you don't have your freedom, right? But you don't want to be a convicted felon because I'm going to tell you in a few minutes some of the ramifications of being a convicted felon. But then you want to also be able to get that off your record in a way so that it doesn't limit your potential in the future. So those are some of the goals that we look at. So under Texas criminal law, you could receive felony probation. People always ask me about that. What's involved with probation? If I don't go to prison, how does probation work? Probation's broken down into two parts. You've basically got straight probation, community supervision, and then you've got deferred adjudication probation. When you start looking at community supervision, you look at straight probation. Here's the downside. If you take straight probation, yes, you do stay out of prison, but you are now a convicted felon. The judge has sentenced you, you have been convicted, and you now have to follow the terms and conditions of that probation. If you fail to do so, the judge could sentence you to the time you received when he probated your sentence. Now, the only benefit to that type of probation is it maxes out your exposure. So here's an example. Let's say you take a 5-year sentence probated for 2 years. The maximum sentence you can get is 5 years, no matter what happens, because the judge has already sentenced you to the 5 years and it's been probated for 2 years. But what if you receive deferred adjudication? Deferred adjudication is a type of probation where you do plead guilty, but you are never found guilty. The judge essentially pauses the case, and the benefit is you're never a convicted felon. And depending upon the type of case that you have, if you complete the terms and conditions of your probation, you may be eligible to receive a non-disclosure to seal those records from public view. The downside is this: when you take deferred adjudication, if you mess up the probation, your exposure is all the way up to the maximum under the law. Okay, so your actual prison time is not capped. They can give you the amount all the way up to the maximum under the law. So those are some of the things to consider. Now I'm going to give you a quick little thing. What if it's a state jail felony? There is a special rule under state jail felonies where you can get a different type of kind of hybrid sentence called a 1244A, but this must be negotiated. It's not a mandatory thing. It's a discretionary thing based upon your criminal defense attorney negotiating it. A 1244A is a type of sentence that everyone talks about up at the courthouse where you may be charged with a felony, but instead you receive a misdemeanor punishment. So instead of going to prison, maybe instead of going to prison for 6 months, you could receive like a 90-day jail sentence. And under a jail sentence, many times you can serve 2-for-1 or 3-for-1 credit where you get out quicker, you don't ever go to prison, and you remain local. The downside to a 1244A is that it is a permanent conviction on your record. You are now a convicted felon. Okay, so these are just some of the examples of things that are specific to the type of crime when you look at a state jail felony. Now, what are the consequences? Remember I told you, number 1, stay out of prison. Number 2, don't become a convicted felon. Why? Well, I'll tell you why. If you become a convicted felon, there are several rights that you lose. You lose the right to vote. Under Texas Election Code Section 11.002A4, it prohibits felons from voting until they complete their sentence, parole, and or probation. Okay. Now, the good news is you can get some of those rights restored over time, but in the meantime, you have no ability to be involved in the civic process. Not just do you lose the right to vote, you also lose the right to be on a jury panel, so you can't serve on jury trials. But then here's the big one that catches most people. You can also lose the right to possess a firearm. You can lose the right to bear arms. So your Second Amendment rights can very much be limited if you become a convicted felon. And so even though Texas law allows that you can receive some of your rights back 5 years after the completion of your sentence or your probation, federal law trumps state law and basically says that it can still limit your rights for much longer than that, literally possibly for the rest of your life. So the reality of it is it's practically impossible to purchase a gun by any legal means if you have been convicted of a felony, and that's under federal law. So if you do wish to possess a gun, you need to make sure you're dealing with an attorney to resolve your felony case in a way where you are not going to be a convicted felon. Okay, now look, I could get into other additional consequences, and I'm sure many of you already know this. If you end up taking a felony and it becomes a conviction on your record, if you have aspirations of becoming a doctor, a nurse, a lawyer, a real estate professional, an engineer, someone who needs access to government resources, a felony conviction can make you ineligible to be a part of those types of careers. But not only that, it can actually eliminate your ability to receive government benefits. So if you've been receiving government benefits, if you become a convicted felon, you could become ineligible from receiving those benefits in the future. Okay, so a felony conviction can also stay on your record it will stay on your record for the rest of your life, and it'll limit your ability to be able to gain employment, and I mean meaningful employment, because people do not want to hire convicted felons for the most part. So that's why it's important to resolve your case in a way that you can get it expunged from your record. So what if you haven't been convicted of a felony yet? What can you do? Well, let me just tell you what your attorney needs to do. Just a couple of things to be aware of. Your defense attorney, whoever you choose to work with, needs to get access to the police reports, get access to all the evidence, sit down with you, go over it in detail, determine what your specific case issues are, analyze the strengths and weaknesses of it, put together a strategy. What can be done to provide you the best criminal defense possible, and how are you going to get there? That's one of the most important things to be done. And by the way, if you have some weaknesses in your case and your attorney does this early in the process, they can prepare a packet of evidence to present to a grand jury. Under Texas law, every felony in Texas has to be indicted by a grand jury. So your attorney may be able to present a packet of information and evidence to that grand jury, which could lead them to make the decision to either keep it as a felony, they might choose to lower it down to a lesser charge of a misdemeanor offense, or you could really get excited about the fact they might no-bill your case. If a grand jury no-bills your case with the help of the efforts of your attorney, now you are literally exonerated. Your case is over, you've been cleared of all charges, and you ultimately will be eligible to have the arrest and the charges expunged from your criminal record. So now, How do you get it? Some people are listening to me saying, I've already been through all this, but I still got this felony. How do I get it off my record? How do I make sure the felony arrest comes off my criminal record? Let me tell you very quickly. In order to get a felony off your record, your case either had to be dismissed, a no bill by a grand jury, a not guilty verdict at a jury trial or at a bench trial, or your felony would have had to have been dropped all the way down to a Class C ticket citation deferred that you completed, okay? Those are the 4 ways that you can get an expunction. So it's important, once your case is over, it's too late to go back and become eligible for an expunction. So the time to fight to make sure you're eligible to get this off your record is now, not when it's all over with, okay? So it's critical. I get that question all the time. So I wanted to just give you a brief overview to understand what should your goals be if you're charged with a felony in Texas. And I've laid it out for you. You don't want to go to prison, right? You don't want to be a convicted felon. You don't want this on your permanent criminal record. These are things you need to sit down and make sure you and your criminal defense attorney that you choose to work with are on the same page, and that criminal defense attorney can chart you a path to that success, okay? So if you are facing a felony charge in the North Texas area, don't hesitate to contact our office. At our office, we provide a free case analysis, and at the Hampton Law Firm, we'll be happy to give you a free consultation. So don't hesitate to contact us at 817-877-5200. And if you'll click on the link down below, I promised you if you waited till the end of this video, I'd give you a free ebook, What to Do If You've Been Charged with a Crime in Texas. Listen, if you liked what you heard, subscribe to our channel. I'll send you more great content like this. And I want to thank you for joining us here today. Look forward to seeing you on our next video.